Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru Tumarkin and the Western Canada Disability Practice Leader. Please send to us your questions via social media platforms and I'll get through them as soon as I'm able to. We've got 30 minutes, so let's get into it. One thing that keeps popping up, and I think this will continue to be an issue way into the future as well, is workplace bullying and harassment. I've spoken about this before, but I think it's worthwhile having another discussion about it. When you have a claim that is as a result of workplace bullying and harassment, and you've got disability coverage through your employer, and you then go off work because of a mental health illness, because of the bullying and the harassment, there's a good chance that your claim may be denied if the documents that are submitted in support of the claim are not completed correctly. What I mean by that is you have to understand what it means to be disabled within the meaning of a disability policy. The test for total disability in a disability policy, if it's a group policy or probably individual as well, is you have to prove that due to your illness, you are unable to perform the essential duties of your own occupation. Now, that's key. There's a difference between own job and own occupation. Own job would be where you're working at now. But when these policies are written, and some of them even say what I'm going to say now, the test is whether you're unable to perform the duties of your own occupation. And the way that that is interpreted by insurers is they look at whether if you were placed in a different location or a different branch or even with a different employer, where the person who was performing the bullying and the harassment is no longer there, would you be able to perform the duties of your occupation? If the answer is yes, then you very likely may not be approved for disability benefits. The test is, are you unable, due to the mental health illness that you have now suffered as a result of the bullying and harassment, are you unable to perform the duties of your own occupation? Since I've been doing disability claims, I've always seen cases like this. We constantly have phone calls from people who have been denied because the insurance company may say, this is an issue between you and the employer. This is a workplace issue. It's not a disability. And if your position is going to be, well, if colleague X is no longer at the company, of course, yes, I can go back to work. Well, then you're not disabled within the meaning of the policy. If it is, it doesn't matter where I work. It doesn't matter if I go back to this employer or any other employer, because of my mental health decline and the restrictions and limitations that I have as a result of my mental health illness, which yes, may have been caused by the bullying and harassment, I'm not able to go back to any workplace at this time. I first need to be treated to the point that I'm able to go back and perform the duties of my own occupation for any employer in any setting. If that is the position, and if the medical evidence supports that position, then your claim should be approved. But if you go and say, look, I can work somewhere else doing the same occupation, as long as it isn't with this employer, you very likely will be looking at a denial. We have our first question. This question comes from Linda Halliday, and she says, what can an employee do when other workers mock, slander, or make fun of others in the workplace who have disabilities? It's usually indirect harassment. The harasser knows there is a person with a disability present. Linda, I think that, and I appreciate that question, thank you. If the person who is being bullied and harassed has as a result of this, a mental health illness that prevents them from performing the duties of their occupation, they should be speaking to their doctor and having a discussion whether it makes sense to go on disability. In other words, to file a disability claim if the doctor supports that they are unable to perform the duties of their occupation. But I think your question also has a component leading to employment law issues. And I would invite you to tune into our employment law Q&A, where this would be an appropriate question to ask. I would imagine that there would be human rights issues at play here. As you can see on the screen, The employment law Q&A will happen on Thursday, February 6th, so in 2 days from now, at 2 p.m. Eastern Standard Time with Jeremy Herman of our office. There's a question from Daryl on Facebook. Are you able to help with CPP disability denials? Yes, our office do have people. We've got a few people who do handle those types of claims. So if you do have a CPP disability claim that has been denied, by all means, please reach out to us, to our intake team, and we can direct you and put you in touch with somebody who can assist you with respect to answering questions as to how that is done. Remember, CPP disability is a federal benefit. It's not provincial, so it doesn't matter in which province you really are, because it's paid by the federal government. Just to recap, our office, well, our firm has offices in Alberta, Ontario, and BC, and we represent clients throughout Canada other than in Quebec and the territories. So if you do have a claim, if you have a question regarding a disability or employment issue, please reach out to our firm. You're very welcome, Linda. A question from Nelly Olsen. What happens if your insurer has cut you off saying they have evidence to show you are not disabled? Well, if they say they have evidence to show that you are not disabled, that almost sounds like they may have conducted surveillance. If they're saying we have considered the evidence and we think that you are not disabled, then that may be a different issue. But if they say we have evidence that we believe show that you're not disabled, it sounds like they conduct surveillance, which they are relying on. In cases where there is surveillance, I've had lots of cases like that. And I often would say to the insurance company, if there were 3 or 4 days of surveillance and they have my client doing things that show that the client may be able to take out the garbage or drive to take the children to school, where they say they have difficulty doing those things, but then the next 3 days they don't leave the house, I always say to the insurance company, well, your surveillance is actually helping us, because we don't see what happens. Where's the person the next 3 days? Why are they not leaving the house? Because when they exert themselves beyond their capacity, they suffer. So, of course, that's not applicable to every case, but sometimes you can use surveillance that the insurance company has conducted against them. But of course, if there are instances where the insurance company does do surveillance, and through a private investigator, and it shows that what the person is saying, the insured, the person who's on disability, is saying they cannot do, is quite obviously not correct, because the insurance, the surveillance shows that they are quite able to do those things, then it is a much more difficult thing to deal with, because then it goes to credibility. There may be proper reasons for them to be able to do those things. There's often the good day, bad day argument, but it really depends on a case-by-case analysis. So for Nelly, for you, if the insurance company is saying that they are cutting you off because they have evidence to show that you're not disabled, I highly recommend that you reach out to our firm and we can put you in touch with a lawyer who can then assess whether there is a claim to pursue. In most instances, there is a claim to pursue. Ultimately, people go on disability because they have their doctor support. I've had this argument with other lawyers who represent insurance companies all the time. Why would anybody choose to go on disability where they only get a percentage of their monthly income? Why would they choose that if they're able to work? Why would they choose to do that? Because they're losing money. Then, and obviously, considering the cost of living increase, it is very difficult to maintain a living these days. And on a disability income, I wouldn't see that anybody would willfully choose to do so unless they cannot work, which is usually the case. And that's why the doctor supports that they go on disability. If there's surveillance that has been conducted that shows, as I said earlier, that the person is a little bit more functional than that they may have presented to the insurance company on some forms that were completed, usually they do that in the context of, generally, I cannot do these things. Doesn't mean they cannot do it at all. But total disability doesn't necessarily mean that phrase, total disability. It simply provides that you have a condition that prevents you from performing the essential duties of your occupation, which is another thing that we often see. The insurance company may have a claimant attend something called a functional capacity evaluation, where the person is put through a battery of tests through a workday, or maybe let's say 4 hours, where they are observed, where they are seated trying to do some typing, to do some other things, to simulate maybe what a shorter workday would be. So in that context, there may then be a conclusion that the person is able to work. But that's simply a snapshot in time. There's not always a follow-up to see what the person was feeling like the next day when they put themselves through this 4 hour of testing. And usually it is the case that because of that, their condition worsened for a period of time. They may have had an exacerbation where they were then completely bedridden. I've seen cases like that. I don't say it's happening in all of them, but just because, same thing with the surveillance, if they see you do something within a snapshot of time, doesn't mean that you're consistently able to do that. So if you do have a denial based on the insurance company saying, well, we've seen you do all these things, we don't believe that you're disabled, that's their position. But there may be a different picture here. There may be a completely different story. So if there is a denial, at least reach out to us and we can discuss with you what your options are. We do offer free consultations. So what we usually do is when somebody contacts us, and you can see on the screen, go to disabilityrights.ca. When somebody contacts us, we review the denial letter. We may look at the supporting documents, and if the policy is available, we will review that as well. Then we will discuss with you what your options are. If at the end of that discussion, you will have a better idea as to how to handle it, by all means, go ahead with that. We represent people with respect to pursuing a legal claim, which means that when we're involved, the person no longer has to deal with the insurance company. All communications go through us. Our job is to make sure that we can get our clients the best compensation that is available. And at the other end, the client's focus should be to continually see their doctors, follow recommended treatment advice, and report to their doctors their ongoing struggles. And then, of course, focus on your treatment. Linda Halliday says, can a worker exercise employment rights and leave the job site after being harassed or bullied because it continued on, and ask the person to stop? What can a worker do when violence is threatened on the job site by the same worker harassing? What is the legal procedure to exercise the employment right to walk off the job site? So, Linda, that really is an employment law question. I would invite you to pose that question on Thursday when we have the employment law Q&A, which will be entirely focused on employment rights. E. Bronte says, what can you do if you don't have a family doctor but are trying to submit an LTD claim? It is so unfortunate that this keeps happening, that people struggle to find a doctor. The only thing that I can say is try and find a walk-in clinic. Even if you have to go to the emergency room, try and see if there is some other option to access online visits with doctors. I know that there are some online forums where people can access telehealth. Contact the local governing body for doctors to see where there are doctors accepting new patients. See if you can find somebody who can have you directed to, even if it is a nurse practitioner. The policy requires that you are seen by a physician. Right? All policies would say that you have to be under the regular care of a physician, which usually is a doctor. But that is so divorced from the reality of what's happening in this country that there are so few family doctors and so many people not having a family doctor. So if you can show that you've done everything in your power to try and get in to see a doctor, even by going to walk-in clinics, that is going to go at least as far as you can with respect to an issue like that. I am concerned that we do see this more and more these days, that people are struggling to find family doctors, but there may be other types of avenues that you can inquire. I know that some cities have primary care clinics now, primary care urgent clinics, where you may be able to get in to see a doctor, because every time you see a doctor, at least there is a paper trail. There should be an entry as to what you were there for, what you were complaining of, and maybe what treatment was prescribed. That would be my recommendation. So do your utmost best to get in to see anybody in terms of treatment, and do that on a regular basis. Okay. Question on YouTube from Jason J. My insurer wants me to see an occupational therapist, but I don't really understand what this is for or why. Can you explain more about this and if I could be worried? One thing that I always say, and I know I sound like a broken record every time that I do one of these, is you have to see your doctor on a regular basis. And the reason for that is, like, something like this comes up, then you can discuss with your doctor what is being recommended and why the insurance company wants to do that, and whether the doctor supports that you see an occupational therapist. Now, this question may have two responses. The occupational therapist may be there to conduct a functional capacity evaluation, which means that the insurance company is not sending you to this person for treatment. They're sending you there to have a functional capacity evaluation done to gauge what your restrictions and limitations are from a functional basis. Are you able? So ultimately, the request to the occupational therapist is going to be, can this person work and at what level? Maybe a sedentary level, maybe a mid-labor type level. They're going to be testing what your capacity is. That's what a functional capacity evaluation is, and it's usually conducted by an occupational therapist. If you cannot go because you have restrictions or limitations to the extent that it may worsen your condition if you attend such an evaluation or assessment, have your doctor weigh in here, because I have seen cases where people have gone to these and their condition has worsened. I've seen cases where the insurance company, because the policy allows them to do this. Remember, an insurance company can, under the terms of the policy, conduct examinations, but it has to be done on a reasonable basis. If the assessment itself carries with it a risk that your condition is going to worsen or be exacerbated, or that you will have a setback, then it doesn't make sense to do it. Then you would have to have your doctor put in writing why it is ill-advised and not recommended for you to attend such an assessment. And if the insurance company insists that you do so, please reach out to us so we can give you further advice. The other option may be that the insurance company wants you to see an occupational therapist for some time of return to work planning. Again, have your doctor weigh in on this, whether it is appropriate for you to attend such a treatment program or to enroll in a rehabilitation program. Should you be worried, remember the insurance companies do continue to assess claims. And if there is evidence to them that you may have capacity to engage in a rehabilitation program or vocational program, they may decide to have you engage in that program. And that's why I say continue to see your doctor on a very regular basis, so that if your doctor disagrees, you can report to your doctor, this is what they're doing, and your doctor can hopefully put in writing why the doctor disagrees. It's also important to continue to see a doctor during this period of time when you are engaged in such treatment or in such a program, especially if it's a return to work program that is done in the background of a rehabilitation program. When the insurance company says, we're going to have you participate in this program for, let's say, 3 months, and at the same time, it is return to work focused. So it's geared towards strengthening you to allow you to get back to work. While you're engaged in that program, let's say you do it because your doctor may say, okay, well, let's see how it goes. Just try. If your condition worsens, it is imperative that you report to your doctor on a very regular basis while you're participating in this program how you're struggling, if you struggle. If your condition worsens, you want to make sure that your doctor knows that the doctor records it in the clinical records, because if the doctor doesn't, it would simply be your word to that extent. It would be much more helpful to you if your doctor ultimately supports, if this does happen, that you're not able to participate in a rehabilitation program any further, because it poses a risk to your health to the extent that your condition will worsen and that you have suffered a setback. And if that happens, the disability will be much longer before you are in a position to return to work. Okay. Then we have a question from BC or Pinoy. I'm on LTD right now, and my insurance company wants me to undergo rehabilitation or functional evaluation, but my doctor said he is the one to decide when I should go for evaluation. Who am I going to follow? So your question, BC, is very apropos considering what I've just discussed. Your doctor says he is the one who's going to decide whether you can return to work, I'm assuming, or participate in a rehabilitation program. The insurance company, though, under the terms of the policy, does have the right to have you assessed, but it has to be reasonable. So if your doctor says this is not something that you should participate in, the doctor has to qualify and support the decision for you not to do that. And usually it would be in the context of, I don't think it's appropriate. I think the person's condition can worsen. There's a risk that they will suffer a setback, that the disability might be much longer. You still will be at risk of the insurance company looking at it very seriously and saying, well, we disagree. So I think in your case, it makes sense to at least reach out to our firm and have a discussion as to what exactly is happening here. Is the insurance company mandating that you attend an assessment, or are they suggesting that you attend a rehabilitation program? Usually they do want doctors to sign off on it. And if the doctor doesn't sign off on it, then they would have to say, then the doctor would have to, as I said, support in writing why they don't agree. So it's not an easy question to say, well, follow your doctor's advice or follow the insurance company's request. Usually I would say follow your doctor's advice, because your doctor ultimately knows who you are and what your condition is. But I think in this case, we would want to have a little bit more information as to what exactly is being suggested here, and what is the insurance company requesting, and what ultimately is your doctor saying. I hope that helps. Linda says, another question, can a worker record conversations on hidden device where they are part of a conversation where the harassment is taking place? Again, Linda, that is an employment question. I do recommend that you speak, or at least pose your questions to my employment team during the employment Q&A on Thursday with Jeremy Herman. Okay, so there's a few more questions that have come in. Let's go to Peter's question. How long does an LTD insurer have to approve or deny a claim once all documents are submitted? The policy doesn't outline how long they have. Usually they say to you, we're going to do it. Well, I don't know if they actually say how long they're going to take. I would take the position that an insurance company has a duty of good faith to its insureds. In other words, to the people who are covered under the policy. So if you submit a claim to the insurance company and they say, well, we need more information. I've had people contact me where the insurance company has taken months to make a decision, which I don't think is reasonable, obviously, because when this is happening, the person is not receiving any income. Some insurance companies have become more alive to this because they know that they're at risk of, if this did go to a legal claim situation, because of the extensive delay, that there may be a finding of damages against them if it did go to that extent. So what they've done is they've made without prejudice payments, while they say we continue to assess the claim and we continue to gather information, but we're making these without prejudice payments to assist you. But we reserve our rights based on the policy. Others don't do that. So when this does happen, if it takes some time, I always suggest that somebody puts in writing to the insurance company the extent of the stress, and not just the financial, but also the emotional stress that they are suffering, that they be the squeaky wheel, that they contact the insurance company consistently on an ongoing basis, and if there is no response, to go up the chain, because you're dealing with a case manager. So if the case manager is not responding to you, if they're taking too long a time to adjudicate the claim or to make a decision, raise this up the level. Go to the case manager's manager. If they're not getting a response, go to their manager, but make sure that you continue to raise awareness as to what is happening with your claim and the difficulties that you're experiencing as a result of the denial, as a result of the delay. If there were to be a denial, then ultimately you could come back, if there were to be a legal claim, and point to all these things that have happened as a result, and there will be a paper trail that you can show. I tried to communicate with them. I submitted all the information that they requested to them in a timely manner, and they still took their time to make a decision. If Bronte says, if struggling to get on to disability insurance makes your condition worse, is there any punishment for the insurance company? It depends on the circumstances. I do want to say yes, that if there were to be a legal claim and if the insurance company had satisfactory evidence, they call it satisfactory proof of claim. sufficient proof of claim from your treatment providers that you are disabled within the meaning of the policy, and they're not approving your claim, or they have denied your claim, and you're engaged in this ongoing appeal process, which really doesn't make sense, and ultimately your claim is approved, if it ends up in front of a trier of fact, then all these facts will be considered by the trier of fact as to whether the insurance company should be punished through something called punitive damages. Punitive damages are paid or awarded by judges ultimately in the context of a situation where the insurance company breached its duty of good faith to you. A disability policy is a peace of mind contract, which means that if you were to submit a claim, the insurance company has to deal with you and treat you with a duty of good faith. And similar to the earlier question, if this continues to be an ongoing denial, or if it continues to be a situation where the insurance company is not making a decision, and that does lead to an exacerbation of your condition or a worsening, and ultimately there is a decision that your claim should be approved, you could theoretically claim that type of outcome. There are cases that I've seen where the insurance company's conduct did worsen a person's condition, but it is very, very fact-driven as to whether it would arise to the level where a damages claim can be pursued. If the insurance company is not approving your claim or has denied your claim and you're engaged in the appeals process, please reach out to us, because there's something called a limitation period that is running. And the limitation period is the timeline within which you can pursue a legal claim. And the moment that the claim was denied, or the moment that the insurance company terminated a claim that was paid, the limitation period starts to run. Which means that if you engage in the appeals process afterwards, after the denial or the termination, that doesn't stop the limitation period within which to pursue a legal claim from running. And you may be engaged in this process in good faith, think that you're going to make a very convincing argument as to why the insurance company should pay your claim. But remember, that limitation period continues to run, and you want to make sure that it doesn't expire while you're engaged in the appeals process. So again, if your claim is denied, contact us, and we can have a discussion with you as to what your rights are, what your options are, and you can make an informed decision as to how to proceed. Peter, I suggest if you had a discussion with the case manager, because Peter says he's had a discussion with the case manager, and the case manager said that they need to get updated or more records, and you've been deemed catastrophically impaired due to psychological and cognitive issues, have your doctor write a letter as to how this delay is further negatively impacting your mental health. Have that letter sent to the insurance company, to the case manager, but also elevate it to the case manager's supervisor and their manager, so that they know that this delay is very negatively and adversely affecting your mental health. Hopefully, that will lead to an approval of your claim. If it does not, please reach out to us so we can discuss what your options are, because this is the type of situation where the earlier question, can it lead to a damages claim, could be applicable. So you can go to disabilityrights.ca to get further information. And that brings us to the end of today's session. Thank you for joining. As I said, on Thursday, there will be an employment Q&A, and I know some of these questions definitely are employment related, so I highly recommend that you participate in that forum to pose your questions on Thursday. And you're very welcome, Peter. I wish you all the best, and I do hope that it works out for you. If it doesn't, by all means, give us a phone call. Thanks again for joining in today, and tomorrow, on Wednesday, which is tomorrow, there will be another Disability Law Q&A with Tumarkin, which is February 5 at 1 p.m. Eastern Standard Time. Thank you again for joining, and have a great day.